Losing a loved one is one of life's most difficult experiences. In the midst of navigating profound grief, you are suddenly faced with a maze of complex legal responsibilities, with one word often looming above the rest: probate. The process can feel overwhelming, but you do not have to walk this path alone. Our goal today is to demystify probate, providing you with clarity and support during this incredibly challenging time. Please remember that this video provides general information and is not legal advice. Always consult a qualified attorney for your specific situation. When a loved one passes away, you might hear the word probate thrown around. But what exactly is probate? Simply put, probate is the formal legal process of administering a person's estate after they die. It is a court-supervised procedure that ensures the deceased person's final debts are paid and their remaining assets are distributed properly. Think of it as the legal system's way of securely wrapping up a lifetime of financial affairs. At its core, probate is a supervised transfer of assets. Imagine a funnel. All the property the person owned, such as a family house, a vehicle, or savings in a bank account, is funneled through the probate court. The court then officially clears and distributes these assets directly to the rightful beneficiaries. This entire process is usually guided by the deceased person's last will and testament. The court validates this document to ensure everything is handled exactly as they wished, setting the legal foundation for the road ahead. At its core, probate serves several crucial functions. First and foremost, it exists to validate the will. When someone passes away, the court must confirm that their last will and testament is legally binding, ensuring their true final wishes are honored. Second, probate creates a formal process to identify and value the deceased person's assets. This means locating bank accounts, evaluating real estate, and taking an inventory of personal property to determine the exact value of the estate. Third, it ensures that any outstanding debts and taxes are settled properly. Before anyone inherits, the estate must clear its financial obligations with creditors and the government, protecting the beneficiaries from future legal trouble. Fourth, probate guarantees the orderly distribution of assets to the rightful beneficiaries. The court oversees the transfer of wealth, making sure every individual receives exactly what they are entitled to under the law or the will. Finally, the process provides a clear title. This is especially important for real estate, as it legally transfers ownership and proves that the new owner has the absolute right to sell or keep the property without any legal cloud. The probate process can feel overwhelming, but breaking it down makes it manageable. Step 1 is filing the petition. You or your attorney will submit an application to the local probate court, along with the original will and death certificate, to formally open the estate. Step 2 is the appointment of the personal representative. The court will officially appoint an executor, if named in the will, or an administrator if there was no will. This person is legally authorized to act on behalf of the estate. Step 3 involves notifying heirs and creditors. The executor must officially inform all beneficiaries and potential creditors. This often requires publishing a public notice in a local newspaper to alert unknown creditors, starting a legal clock for them to submit claims. Step 4 is the inventory and appraisal of assets. The executor must identify, gather, and protect all assets belonging to the deceased. This includes having real estate, antiques, and other valuable items professionally appraised to determine the estate's total value. Step 5 is paying debts and taxes. Before anyone can inherit, the estate must settle its obligations. The executor uses estate funds to pay valid creditor claims, outstanding mortgages, funeral expenses, and any final income or estate taxes owed. Step 6 is the distribution of assets. Once all legitimate debts and taxes are cleared, the executor petitions the court for permission to distribute remaining assets. After approval, the inheritance is finally transferred to the rightful beneficiaries. The seventh and final step is closing the estate. The executor submits a final accounting to the court, detailing every penny that came in and went out. Once the judge approves this report, the estate is officially closed. What happens if a loved one passes away without a will? This is legally known as dying intestate. Without a will, the deceased no longer decides who gets what, and the state steps in. Assets are distributed based on your state's specific intestacy laws. The court divides the estate among the closest living relatives, usually split between a surviving spouse and children. Remember, every state has different rules for exactly how this pie is divided. One of the most effective ways to bypass probate is by creating a living trust. Assets placed into a trust are no longer part of your probate estate, allowing them to transfer directly to beneficiaries without court involvement. Another strategy is joint ownership. If you own property or accounts jointly with rights of survivorship, those assets automatically pass to the surviving owner, skipping probate entirely. Payable on death and transfer on death designations are simple but powerful. By naming beneficiaries on bank accounts or securities, these assets transfer immediately upon death without needing probate. For estates below a certain value, many states offer small estate procedures. Inheritors can claim assets using a simple affidavit, drastically reducing the time and paperwork involved. Finally, gifting assets while you are alive reduces the size of your estate. Just be mindful of annual gift tax exclusion limits to avoid unexpected tax consequences. Unfortunately, probate is rarely free. The costs can quickly add up, often taking a notable percentage of an estate's total value before your loved ones see a single dime. Expect to pay anywhere from 3 to 8% of the estate in probate fees. A large portion goes to attorneys and executors, followed by court costs, appraisals, and administrative expenses. Beyond the financial toll, probate demands a significant investment of time. Even a relatively simple and straightforward estate can take anywhere from 6 months to a full year to settle. However, if the estate is complex, involves a business, or if family members contest the will, the timeline extends drastically. In these situations, probate can easily drag on for several years. Navigating the probate process can feel overwhelming, especially while grieving. That is why seeking professional legal counsel is often the most important step you can take. An experienced probate attorney can help you avoid costly mistakes, interpret complex state laws, and handle creditor disputes on your behalf. To help you get started, probateus.com serves as a valuable starting point. While it does not offer legal advice, the platform provides essential resources and directly connects you to your local courts to find specific rules and necessary forms. Just enter your location to take that first step toward finding clarity in a difficult time. Thank you so much for watching our guide. Navigating the legal system after a loss can be overwhelming, but we hope this video has helped demystify the process. We have covered what probate is, why it is necessary, the steps involved, alternatives, and how to find help. If you found this guide helpful, please like, subscribe, and leave your questions in the comments below. Visit probateus.com for more information and to locate your local probate court.